anyway, I realize that some of you guys don't know what the master file is. When we say the master file, we're talking about the extent of all our knowledge and expertise in regard to how one would correct their status in commerce. So because for the most part, I'm the full-time, all the time researcher, and I do have others that contribute significantly to the research, but they have 9-to-5s and other jobs and things like that. So they're not able to dedicate as much time to the structure of what is necessary for ourselves to correct our status. So that's what I've been doing, and I've put all that research in a structured form called the master file. It's very intentional that I try to keep the essence of what needs to be done to one page, as so that you're not overwhelmed, and so that you can partition this mentally the way that you will until you understand every particular part of this, because you should be studying this master file for at least 1 month, and before you go on to start doing everything in it. You should have went through everything mentally within your mind and researched it and kind of did a dry run within your mind before you even start ordering the QSIP search results and you start bringing things into action. Because honestly, when you get ready to do this recording and you have everything in place, you want to be able to have it all done in maybe 2 weeks, ideally. Just everything, 2 weeks done, as far as to the extent of what you have to do. But that's not going to happen unless you see the whole big picture. And that's what this whole blueprint is here to demonstrate. And we try to keep it, at least the essence of what needs to be done, to one page. And if you can see here, this is one page. It starts up here and it goes down a little bit further. And down here you see the older videos. The latest video, such as the one I'm doing now, by the time you get this, will be here. And this video will be down to the bottom, right? So this is how this works. Now, to receive this, you can make your $150 donation to coaching@thctrust.org via PayPal, or just go to the website www.thctrust.org, create an account, which is free, log in, and it'll direct you to how to make a donation to receive the master file, if that's what you would like to do. Now, in my opinion, this is the best research out of everyone else's research out there in regard to how one corrects their status in commerce. And I'm not saying this from any type of way of being conceited. I extend that out there to everyone. I extend my work for peer review, and iron sharpens iron. So when I do learn something, as many of you guys who've had the master file, you see I go in there and I correct it and I update it. So nothing in here, I can't direct you to how I came to that conclusion. And I really respect intelligent questions. That's why my number is provided to everyone who makes the donation for this. It's not for me to coach you or tell you or instruct you how to do, but if you have legitimate questions about the process or the procedure, or maybe there's something that you don't quite agree with, you can, call me up, and then we can discuss those, and either I'm going to convince you or you're going to convince me of something that I didn't know, and an update is going to go in this master file. That's how it works. I really respect that. I got a call from someone the other day, and they weren't against it, but they just, because of the information that they had, they were kind of wondering how was I using, or how were we using the QSIP search results, which is not just all, let's say, it's not just shares of interest that just you own. It's beneficial interest in common. So how am I using that in commerce as an affidavit of title? So then I got to demonstrate to him, which I'll be talking about when here in a certain area, that the affidavit of title over the particular estate evidenced by the certificate of live birth and the material fact of the QSIP search results attached thereto creates a collateral interest. That's what I was trying to say. Why is the collateral interest important? Because, many people are trying to figure out, well, how can I use this birth certificate? So that's what we're essentially doing. When we do the QSIP search results, we're evidencing a particular transaction to where there's a reversionary interest, and it's a collateral interest because the estate, which holds the trust, gets to hold the property, the titles, the leases, and the rents, the accounts due, the accounts receivables for the trust, including the reversionary interest, including the entitlement, the collateral interest that's evidenced by the document of title, which is the affidavit of title on a certificate of live birth recorded in the county. That establishes a record of a collateral interest. It gives you a docking number, right? A docking number. A docking number to identify an asset. And that asset is what we have to have, that asset in the county, that real estate is what it is, basically. But the asset, but what the real estate is, let me quantify that. It's the chattel papers, the documents of titles, the deeds, the acts. So for example, your affidavit is an act, it's a deed. Your declaration of trust, which your exhibit A, and the certificate evidencing the estate attached thereto, that is a deed, it's an affidavit, it's a chattel paper, it's a document of title, and it's considered real estate. I covered that in this video right here. So I don't want to kind of get off the subject, because that's why I have all these different videos that you have to go through just to understand what is taking place. So the reason why I was again mentioning the collateral interest is to help some people with not quite understanding how does knowing that the estate was securitized in this transaction worth hundreds of millions, billions, or even trillions for some people's research, trillions of dollars, how does that help me do anything? Because you can now ledger your collateral interest in that fund. Now, what good is a collateral interest? Now, that is when you get, well, you can use a collateral interest. For example, when you look at secured party creditor bonds, right? Usually you see the bond and it is backed by either silver or a securities account, 3 secured parties pledging assets, right? They have a collateral interest in these assets. So now the bond, which is like disconnected, because the bond is made up by 3 assets. 3 assets are made up by collateral interest that each of the 3 parties have. So now the value is not so significant, because the bond itself that is backed up by the collateral interest in the assets, the bond is going to stipulate its own value in accordance with different contracts. The very first thing that you have to do is you have to record a document of title on the estate. Now, the estate is governed by a will. A man's property is governed by his will, simply put. And I'm going to try to relate this together. And what I'm trying to demonstrate to you is why we are, why we are attempting to record a document of title over the estate in the county. Because when you record title on a estate or a property in a county, it gets indexed to a particular estate, and it becomes real estate or personal estate of that estate. And there's an asset number, there's a docking that occurs, and this takes you into the admiralty and laws of commerce, as deals with title and control of those goods registered to that estate. The birth certificate is evidence of the estate registered. In one sense, when we do the QSIP search results, that's evidence of a transaction to which we have a collateral interest and a beneficial interest. So that is property or parcel to the estate, which is personal property, which is actually considered real estate. And I broke that down in this video right here, how your security entitlement how your security entitlement or your document of title, affidavit of title in the estate how that chattel paper and the accounts that it references is considered by law real estate. So I broke that down in this video right here. And when I said the accounts, rest assured that the certificate of live birth, at least the ones, some of them, depending on which one you have, they show you particulars. They even say particulars, which are several accounts, right? So when you start breaking down the definition of these words, it's like somebody may say, no, you're taking it overboard. No, this is what the definitions mean. And it doesn't matter how far you go, it's going to all relate to the estate, the registration of the estate that you have to take title to, because if not, by not taking title to the estate, you are demonstrating that you are not in the proper status to control the estate. And I'm going to show you that here shortly, because we're going to look at the definition of a will, because remember, a will governs the estate. Now, we're not suggesting right now that you need to go file a will to correct your status. So follow me and you'll see where I'm going with this. And you'll see in one level, this is not all, but I'm just demonstrating one level in this video of why the conclusions have been drawn to do the master file the way that it is. So I want to go to the Bouvier's Law Dictionary real quick, and I'm going to look up the term wills. So here's what a will is. Remember, the will governs the estate, right? And this is why we talk about needing to be an executor, which is basically going to be the same person as the trustee for the declaration of trust that is titling the estate. Okay? So what is a will? In criminal law, it's the power of the mind which directs the actions of a man. Two things I want you to pay attention to. Power of the mind, actions of the man. So this is the mind. So in order to have a will, the will is the power of the mind, or the expression of the mind, if you look it up in other places. It's an act, it's a functionality that requires the mind. So they're almost synonymous in how they're being used against you. If you don't have a will, you don't have a mind, which takes you out of your status of being a man. See, man, that's the one who has unalienable rights. Man is the one who has divine rights because he was created by God. He's in the highest form of law. Man is the one that was given dominion over the earth, right? Man is a status of complete and perfect. A subject or a person is that less than the man, whose estate is controlled by another through a contract. So what's occurring in the US or in the United States, which is why this whole status correction thing is important, because we want to take ourselves out of the corporate ward incompetent civil status. Now here's a disposition, right? And I don't want anyone who's not a Moor to take this the wrong way, who doesn't proclaim their nationality as a Moorish American, because I'm not saying that I have all the answers. I don't, but you have to understand my research is mostly specific to Moorish Americans because I'm a Moorish American. But I want you to pay attention to something here, because in the public, they're always trying to defect you of having a will, because this is what gives a public officer or a judge the authority to administer your estate. The defect or want of a will may be classified as follows. Pay attention to the words classed. The defect or want of a will, that means not having a will, may be classed as follows. So when somebody looks at you and they say they put you in one of these classifications, it's for the purpose of defecting you or divesting you of your status. It's by saying for whatever reason you don't have a will, so you're not of full majority competence as a man. You're less than that. So the defects of having a will could be natural, as that of infancy, right? So you can be a natural person, which is a status within itself, but it's not the same status as a man, because a natural person can be in infancy by defect of a will, right? It could be accidental, dementia, for example, by forgetfulness. Maybe that's relative to being wholly brought into a jurisdiction without knowledge of your nationality, your civil and political status, your customs, right? That could be a form of forgetfulness, which we are now in restoration. Ignorance. Many of us are just ignorant to these things, right? We're ignorant to who we are. We have no knowledge of self. Many of us don't even know that the man is a spiritual being. Notice the mind, the power of the mind. You can't bring me that in your hand. That's not a tangible thing. Bring me the power of your mind. No, that's a spiritual thing, because the power of the mind directs the actions of the man, which is a spiritual thing. These bodies are vessels, right? These bodies are vessels, and this is why they're using the certificate and the registrations and the admiralty and the maritime act, because these are the laws that govern vessels. With the exception, these bodies are land vessels, right? They're land vessels because they come from the womb, they come from the earth, and this is why they're registered as estate. Consequently, the Birth Registration Act is the registration of a trust. You can see that right on the face of the instrument. The estate contains property, accounts. These, on some birth certificates, you'll see these things right here, where it has box 1, and it has a trade name, and it has box 2, it has a sex, and it has box 3. These are called particulars. And you can look up what particulars are. Those are accounts. So that is the money accounts that were created from the land vessel. This is called devolution or de-evolution. You can look it up, Devolution, and it usually deals with title and property. This is the land vessel to the commercial vessel, the de-evolution of real estate to personal estate. So you can argue that this is personal estate or real estate, but it pertains to matters of real estate, right? These are the particles, or the accounts. Really, the registration. You can look up trust and equity law, and you'll find out that a registrar who receives property for the benefit of another, this type of situation, the registrar or the recorder becomes a trustee of that constructive trust, right? So who's the grantor of this trust? Oh, so this is what I was going to say. Let me go back to this, and we'll go who the grantor of that trust is. The defect of the will is accidental, natural, that in infancy. So be careful. Just being a natural person is not as it's not as strong as being in the status of a man, because a man has full rights, and I say man both male and female, right? So you can be a natural person and be in a state of infancy, which is the defect of having a will, which is someone asserting their governing over your mind, right? Which is government. The power of the mind directs the actions of the man. If you are without the power of your mind, you are under the government of a third party, so to speak. So also, when you look under will or testament, the legal declaration, first thing I want you to pay attention to is the legal declaration of a man's intention. The legal declaration of a man's intention, will or testament, of what he wills to be performed after his death. Now, some people say that because the de-evolution is passing the Birth Registration Act takes the land vessel and converts it into personal estate. Some say that's a birth in commerce, if you will. So it's a death on the land and a birth and a commerce in that specific act, which is like just one slice or layer of the thing. So this is why some people, I presume, say that the birth certificate is death certificate. But either way, the thing that I want you guys to notice is that whether in criminal law or even talking about the probates and the estates, This thing about the will deals with the status that only a man can have, and it's an express act, right? So what we are trying to correct with when it comes to our status with this first recording on the land is we're correcting the defect or the want of a will at the most foundational level where the birth registration act occurred in the first place. So this is where Minnesota Rule 220 comes in with the expression of the competency in regarding to holding title to the estate, or or just the affidavit of title. So that being said, everything that's recorded in a county, which is really a territory under the United States of North America Republic, the counties are really territories. And all of these things recorded in these territories, or these counties, let's call them, are land registrations, whether they're titles. You'll find that there always must be a grantor and a grantee. So whether you're putting an affidavit of title or any type of affidavit that's going to convey real or personal property, there's got to be a grantor and a grantee. Same with the power of attorney. That's a document you may record in the county. It's going to have a grantor conveying the powers to the attorney, who is the agent, and that would be the grantee. But it doesn't matter whether it's a power of attorney, whether it's a deed of trust, whether it's a affidavit, whether, there's always going to be a grantor conveying real property, personal property rights or interests to a grantee. So you have to think about that when you're presenting an instrument for recording, right? Because the first thing that we're going to do, once again, is the county recording, where we're recording ownership on the estate in the county. But we want to show that some trust owns the estate. Before I get to that, I was asking the question, who is the grantor, right? So this FS Publication 0049, Department of the Treasury, questions and answers about trusts. This is like question and answer. Here is your answer. You go into this document. Remember, we talked about the body being the land vessel. It has all the things that's in the earth: the iron, the zinc, the gold. What else? All the different things in our body. Same thing that's in the earth, because this is earth. This is land. Land registration, birth registration act, right? But it's the de-evolution of land into personal estate. So, right? So now, anyway, personal trusts are further divided into either under declaration of trust, meaning the grantor and the trustee are the same person, and the grantor controls the trust assets. So again, we talked about the certificate of live birth and the particulars under there, the accounts and the chattels that are created that are deemed by definition of heirlooms and money connected to estates. They are deemed by definition real estate. Who is the grantor of all of those particulars? Is it you? Is it the infant? Well, I'm telling you that it doesn't really matter, because title vests in the hands of the trustee. But I'm not going to answer the question. I'm just going to read this. Personal trusts are further divided into either one, under declaration of trust, meaning the grantor and the trustee are the same person, and the grantor controls the trust's assets. Without this, without this little simple under declaration of trust, you can't even own your own assets. This is the way that the commercial structure is set up. The statutes and the codes and this whole commercial matrix, it's set up like that. So I'll read that again. Personal trusts are further divided into either under declaration of trust, meaning the grantor and the trustee are the same person, and the grantor controls the trust's assets, or a trust under agreement, meaning the grantor and the trustee are different persons, and the trustee controls the trust assets. So what they're not telling you, which is common sense in the first part, when the grantor and the trustee are the same, well, they do tell you they're the same person. The trustee always controls the trust assets. So you'll notice, let's click the secured party filing down here, which is always found at the bottom of this UCC here. And I mean the bottom of the master file. So now we've changed the registration statement, and it says Doe John Alex, which should be trustee, under declaration of trust dated 07717. Why? Because we are following the guidelines of this right here, where meaning the grantor and the trustee are the same person, and the grantor controls the trust assets. So what is a declaration of trust, right? When we just looked at the term, the will, it's a legal declaration of a man's intention of what he wills to be performed after his death. Or you can look it up on other sites and it'll tell you the legal declaration of a man's intention of how he wants to direct the distribution of his property. But it's a legal declaration of a man's intention. And up here, it's the power of the mind. Once again, a man's intentions that directs his actions. So an express trust, what I'm trying to demonstrate to you, is when you declare your intentions for your property, that is an expression of the mind, and that is a will. That is a will. And when the trustee and the grantor retains the rights in the property, that means he can revoke the trust. That means it's a revocable trust. Then you have a revocable trust under declaration. So if you went to an attorney and asked him to write you a living will, the document that he hands you will qualify as a revocable trust under declaration. This is the proper vessel that we want to use to control the estate, the secured party to control the property. Because if it wasn't revocable, then they will use your instruments against you to tighten you into a position where you have the infinite mind because you're a man. So you have that spiritual connection, which is the use of the mind. You have your own will. So the only proper trust instrument for you to manage the estate is one that is revocable, where you are the grantor directing the property and who has interest in what, and you are the trustee because you maintain the rights, title, and interest. Okay? So that was out the treasury document. So now you don't have to say that I'm saying you can be the grantor and the trustee. Now, once again, here's an example. Paul E. White and Mary Cole, trustees under declaration of trust. That's the long statement. This is the abbreviation. Or here's a better one. Paul E. White, trustee under declaration of trust, dated. And then they put the beneficiary in here for the benefit of Mary whoever. But here they just say Paul E. White, trustee under declaration of trust, dated whatever. This is the whole trust right there. That's not any, you don't see the documents or the instruments, but that lets you know who the trustee is, the date of the trust instrument or the declaration of trust, which is an affidavit. Once again, it's a deed and it's a conveyance, because if a declaration of trust, which is a will, I'm going to show you in a second that a declaration of trust, which is an express intention of the grantor, is a will. It's an expression of his will to direct and control property during his lifetime, because it's revocable. But anyways, it's under declaration of trust. This statement tells you that, and it tells you the date of the trust instrument. That's why this trust registration statement, it goes right. This is why this is the secured party's name. This identifies the whole trust. We use last name, first name, middle, because that's the name that gives credit. That's the name of the man. That's his name. That's his common name, so to speak. The man under common law. All right? Because the man doesn't have a name. God didn't give him a name. His name was man. The Lord God gave him a name, right? But God created man, and man is the one who was given dominion. So this is an expression of trust. So all that being said, when you get through this whole master file, you'll understand, how to operate in trust and how the trust is actually securing the estate. But then we're going to start dealing with our nationality, and that's when this Do John is going to become important, because the civil and political status of the trustee is of the utmost important. But we just have to deal with this all in segments. Okay. So, want to go back to the Bouvier's Law Dictionary and show you one more thing here. And this is the legal declaration of a man's intentions. This is within a will or testament to be performed after his death. Now, some people say that because of the de-evolution process, the registration of the private estate into the public estate, it represents the death of the man in common law in one area. So that would be the form of a death. Every birth is a death per se. I'm not here to justify that one way or another, but I do know a will is an expression of a man's intention. And what I want to show you is that it has to be published. A will must be in writing, written on paper or parchment. And I'm not going to read through this whole thing because this is already getting too long, but I want to show you that here it is. It must be published. That is, the testator must do some act. Remember, we talked about an act. An act is an affidavit, a deed, a proclamation, putting something into positive law, right? On the record. This is what the county recorders do. They publish acts, whether by deed or affidavit, that conveys property, interest, title, and rights to estate, personal estate or real estate, right? So a will, it must be published. That is, a testator must do some act from which it can be concluded that he intended the instrument to operate as his will. How many of you have tried to publish a will? You know that doesn't happen here. So this is generally the provisions of what has to be to make a will valid, generally. However, down here it says, among the civilians, they have two other kinds of wills, namely the mystic. And that's the one I want to direct your attention toward. The mystic, which is a will enveloped in a paper and sealed, and the witnesses attest the fact. So what they're telling you is this is a specific certain type of will, and it's for civilians, whoever they may be. And it's a mystic will where, contrary to the normal general course of wills where the act must be published, this will is concealed and just attested to and concealed. So this doesn't really serve to benefit us. And this is why I think this brings us back to when you talk about the defect of the will. In this regard, this defect of the will has to do with, here it is, the defect of the will. When they talk about the third defect of the will is civil subjection, because this specific type of will, which is the mystic will, is authorized obviously here in the United States. So this is due to the civil subjection of the United States citizens and the authority of their property, how they were registered in commerce. Anyone with the birth certificate, that registration occurred. And by that registration, it's evidence of, the birth certificate is evidence of being a United States citizen. It's evidence of being a United States citizen. You got to go into the Immigration and Nationality Act and you'll see that. So the evidence on his face puts you under the civil subjection. And under that civil subjection, the whole estate is being administered under the proceedings in the bankruptcy code. So you have to be in a corporate ward status, and to be able to publish a will in the record of your probate court or any court will obviously be effectively pulling you out of that status. You understand? So this is why many people are met with all kind of resistance when they've tried to go record the will. But what I want to now direct your attention to is, for example, I'm going to show you something else they said. I read in here that all wills are to be recorded in a probate court. But again, if we put this into expression, they're not directly telling you what a will is. This is a term for a will or testament. But I was reading that all wills are to be recorded in a probate court. And what I'm trying to show you, that wills are nothing more than declarations of trust is what they are. Even as we see here, the legal declaration of a man's intentions. Okay? So they have the mystic will, and the reason why I was talking about the status, the civil subjection, is because this is where it's going to segue into the nationality and the civil and the political rights of the trustee, and the actual legal demonstration that Noble Drew Ali, as well as C.M. Bay with the Clock of Destiny, legal demonstration that is fact of record and law that was perfected on a national level, on an international level, and on a state and local level. They hit all of those levels, and nationality has been brought back to Moorish Americans, and that frees us from the civil subjection, because that nationality gives us a certain protected status. And there's treaties and certain international laws that deal specifically with what I'm talking about. But that is going to be later when we get into, all of those different things. And I'm not saying that, there's other routes for other people, but right now, I'm researching what applies to me mostly, so that goes without saying. So anyways, the will deals with the power of the mind. So I think by placing a will on the record, which is a declaration of trust, especially the one that we're doing in regard to the estate, by operation of law, it pulls you out of that corporate ward status, which is that agency relationship. And that agency relationship cannot coexist where a trust holds title to property and collateral. All right, that was a pretty long premise, and I think it was enough. I think that was enough to go now into the master file and the UCC filing itself. Well, just the let's see, where did we go? So we said, okay, here's the deal. This is the most important thing that I have to express here. So by now, I hope that you understand by watching all of this that the first thing that we're trying to do is record an affidavit of title on the certificate of live birth, which evidences the estate. And the QSIP search results, let's look at that one more time. Let's look at the QSIP search results. The QSIP search results, what does this demonstrate? I don't want to go through this whole thing again, but I already kind of did in another video, so you can watch that. But these are the material facts, right? These are the material facts that establish the collateral interest that you are claiming title to. This is the asset that is getting recorded. So this affidavit of title on this certificate, when they give you a state document number and a registration number with the page and book number, that is the asset. Or that is the asset that your collateral interest relates to. The collateral interest gets registered on the UCC so it can be used in commerce. This is the title holder, the secured party, which is the trust, right? So now you understand, why this state recording has to be done first. Now that you understand that, let me further take you into a deeper understanding that even though I've been saying affidavit of title up into this time, it was so that not to confuse you up until this time, but I want you to know that your state recording may not be just an affidavit of title. You may go to your county recorder and record an affidavit of title attached to the birth certificate detailing the specific facts that relate to that conveyance. And they may tell you that we're not going to accept that for whatever reason. So you may say, okay, they're not going to accept the affidavit of title. So then you may go to them with a certification of trust. And for those who don't know, a certification of trust is an evidence of the existence of a trust, and it has whatever records you want to include in there. Many counties are required and obligated to record certifications of trust. So maybe you have to take the affidavit of title attached to the certificate, which represents the estate, and you can add that as property titled to the trust. That's in your private documents. And when you issue the certification of trust, it'll lay out everything you need to say, and you'll have the Exhibit A, which is the certificate attached to it. That may be the other way, where the county says, well, we can't deny or reject a certification of trust, so they accept that. That is what all of these documents in the master file is for. You see different ways here: by affidavit of title, you see by annex of memorandum of trust, and then I put or certification of trust. I'm going to put the hot link in here so you'll have the certification of trust. All of these are hot links and templates, so these give you some options. I always say you start with the affidavit of title, because in some instances they're not even going to give you a hard time, they're just going to record it. But if they don't, then you can kind of go back and forth with them, and you and don't abandon ship. You must put yourself in a mindset that if what they come back and tell you is not sound, you have to precisely respond to them at least 2 times before you say, okay, I'm going to move on to a different method. So just to further clarify, it might not end up being an affidavit of title attached to your certificate of live birth, but everything recorded in a county has a grantor and a grantee, and that demonstrates the conveyance of the rights in whatever property is subject to that instrument, and the indexing of the grantee is the present title holder. So that's why I say just keep these things in mind, whether you're using an affidavit, whether you're using a deed, declaration of trust, memorandum of trust. Let's see, the leaseor and the leasee. This is once again grantor, grantee. Buyer, seller, grantor, grantee. Bailor, bailee, grantor, grantee. So no matter what instrument document you give them, for example, a power of attorney, the one granting the power of attorney is the grantor. The agent or the attorney in fact becomes the grantee. I say that because you may have to record your interest a different way because they're prejudicing your interest too much. And you may have to strategically use a total method altogether. Again, the first thing is the county recording. So ways that we go about that is, again, I mentioned it before, but I want to further go into it, is you do Google searching and you see what's authorized, see what they are authorized to record. Because, like for example, in California, I've already seen certification of trust. And then let's say certification of trust template. You know, and here's one that pops up. I'm not saying you have to use this, but they say certification of trust, California probate code. So this kind of is just right and consistent with everything that I've been saying, right? This is just a Google search. Why? Because I was saying all wills are subject, or they're to be administered in the probate court. That's where they handle that business of wills and estates, right? All wills and estates. So this is why I say you have to go experience over there. See if they will record your certification of trust or declaration of trust. You have to go read this code to make sure that your certification of trust has all the relevant parts. Don't just go off of this form because you found it. You understand? Now, a certification of trust is evidence of a thing done. The declaration is the actual establishment of the trust. So once again, the certification goes back to a declaration of trust, which is what? It's a will, the expression of the will. And we know that in order to be in your proper status, you have to operate through a will in commerce. So this kind of ties in once again why we're demonstrating that the trust holds title to the estate. This is why we need the document of title, whether it's an affidavit, a deed, or whatever. We need it recorded in the county. So, but here's an example. You know, California certifications of trust, you won't find memorandums of trust. So you may have to structure your own document. You might start it with this as a template, right? The undersigned declare under penalty of perjury of the laws of the state of California. I would say under the laws of the California Republic or something. You know what I'm saying? You have to be careful with the jurisdiction that you're according yourself to. So a lot of times counties are territories and states are republics. The trust known as, you'll give it a name, executed on whatever. I would probably use the trust registration state, the trust known as John Doe. Well, yeah, you could use a DBA, but if this doesn't allow you to put the trust registration statement in here, you need to create your own specific, right? This doesn't say the attached schedule or the attached exhibit, so you may have to include that if you want to include the evidence of the estate for which the trust holds title. So I hope that kind of better helps you understand why when we talk about the secured party creditor, the first thing that you do is you do the recording in the county. You do that before the UCC filing. And let me show you, where can I get access to that? Let me see if I can pull up a county recording. Okay, here's an example here. This is not the same thing, but I'm just making, just making it real plain and simple what I'm saying here. See this affidavit of title? This is an affidavit of title right here, all right? And then on here, you have page numbers, and then you can't really see it here. Let's see if you can see it down here. You can't really see it here, but it's a doc ID number. That's a document ID number, a docking ID. So this takes you into the registration of assets under the commercial system. You know what I'm saying? So this is why I'm saying you get this first, because when you get to the UCC, and this is not the status correction stuff, but now it's not the one either. But I hope you better understand that all these affidavits, deeds. Let me show you another one real quick. Another way. Affidavit of successor trustee. This is another one where you can. This is another clause that you can come in and attach. Let's see it pop up here. I just downloaded this. So affidavit of successor trustee. It's another one of those things that you can use to affect recording the title of the estate into the power of the trust, the secured party trust. So all of these are different ways that it can be done. But then you have to find out registrar, probate court, where these things need to be recorded. Sometimes you'll be met with no resistance. Anytime you're met with resistance, you have to respond at least 1 or 2 times with a letter, challenging the positions if it makes sense to respond. Okay, so then once you have all of those, then I keep saying this, but I just want to make sure you get it. Then you can go to the UCC filing. Why? Because notice in here, did I write it? Yes. The registration establishes the securities account and entitlements enclosed and held in trust with all right, title, and interest in common under FBNX, blah, 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 blah. I named all that stuff, including associated chattels, electronics, papers, blah, blah, blah. So anyways, I'm kind of sorry for blah, blah, blah in it, but, I was actually going in here. What needs to be done and what I absolutely will do is once you get your county recording done, you're going to evidence that in here, because this is what, for example, this affidavit of title, it's showing this is the trust that holds title. This is claiming title to the estate. It talks about the chattel papers, the QSIP number, the securitization, the reversionary interest. All of that you can put under your recitals or your, the statements, the facts that pertain to why and how title is held. All that can be there, right? It's attached to the certificate, evidence of the property, the estate, the Schedule A. That's always the part of the affidavit or the deed or whatever. These are standard county recordings. So I'm trying to get you in the mindset of understanding that when somebody's telling you you can't do this, they're denying you the very thing that they're supposed to do all the time without scrutiny and prejudice and discrimination. Okay? So there's your grantee. You know, they automatically know who the grantor is. The John Alex Doe. John Alex Doe. He's the grantor, the one making the declaration. The grantee. This is where he's vesting the property into that trust under agreement or under declaration, etc. But that page and book number that's ascribed to here, that is a private interest on the county, right? Because in commerce, the county, they can't see the man and his common law rights. Well, they can interact with him when he's in a trust vessel. But for the most part, he's a man with these common law rights on land. And this is where this page and book number and docking number and asset goes. Now, when it's recorded in commerce, this UCC1 is a notice in commerce of this what happened under the common law. So it's a notice and it's a registration of the trust in commerce and it's a registration of that trust property. But a notice is a fact of something that's already done. That's why this registration already needs to occur, because the title, the holding of the title will already be proved on the record. That's proving, right? That's why this thing has to be done first. And then you register the security entitlement. The trust is the commercial vessel on land and sea. And you register the property. The evidence of it is here. Hope that's enough. I'm out. Peace.